Thank you, Mr. Mayor. Gentlemen and Ms. Canada Wynn, several of the speakers have already covered a number of the points I was going to make, so I'll just skip to some other points. First of all, I really applaud you for the motion. Let me say, however, that it's really just a policy statement. The Maritime Park Board is bound by Florida law, and what you do or don't do doesn't have any effect on that. And Mr. Mayor, this is a clear violation of the Sunshine Law. This is a not-for-profit private entity that's acting for a public agency. There's a 8-part test called the Schwab test that's applied, and this board comes within the terms of that. It is covered by the Sunshine. It's clear, and furthermore, the Florida Supreme Court itself has said that the public has, as Ms. Myers noted, an inalienable right to be present and to be heard. She also adverted to the fact that the consequences can be pretty serious. Once there's a violation, any official act that's taken is void ab initio. That means at the beginning. That means you have to go back and do everything over again if a violation is established. Also, for civil violations, there's a $500 fine. For criminal, if there's intent shown, it's a second-degree misdemeanor. Query whether there was intent based on the comments that were made Monday night. But in any event, it's abundantly clear that there were civil violations in this matter. Furthermore, intent is irrelevant, and I'll quote from a 4th DCA case. Mere showing that the Sunshine Law has been violated constitutes irreparable injury. It renders the official action void, meaning that a finding of intent to violate or resulting prejudice is unnecessary. Once the violation is established, prejudice is presumed. And by the way, when you go back to redo it again, and in this case in the 4th DCA, the 4th District Court of Appeal said, sorry, board, not good enough. Your redo was perfunctory. You have to have substantial discussion. You have to have real engagement. There has to be actual input. And the 4th District Court of Appeal made them do it over again a second time. So this is a very serious matter, and it has substantive consequences. As the league president pointed out, this board may not have heard about ADA requirements, and so the project may not be designed properly, in which case an expensive retrofit would be necessary, or expensive federal litigation might occur. So it's not a mere technicality. There's substantive reasons for doing this in the Sunshine and hearing from the people who pay for these projects. Thank you.
Okay. Mr. Hall.
Yes, Ms. Barnett. I just had a couple of questions for you. You are an attorney.
I am.
Where'd you go to law school?
I went to Vanderbilt, Mr. Hall.
Vanderbilt, okay. You're a member of the Florida Bar?
I have been a member since 1981.
Since 1981. And you've been involved with a public rights organization for several years?
Yes, I have.
And you've dealt with this issue several times?
I have dealt with this issue several times, yes.
And I believe I've attended at least 2 workshops that you were present at on the Sunshine Law.
I recall one, and actually Mr. Wells was present at that one, and it was at that one that we received these materials from the First Amendment Foundation, in which the Schwab test is articulated, the inalienable right of the public to be heard, as held by the Florida Supreme Court, is set forth. That's right.
So even though Mr. Egan may not have realized it at the time, his statement that it was a clear violation was correct?
It is, in my opinion. Yes, it is.
Thank you.
There are close cases. This is not a close case, in my opinion. In fact, that's why I asked the league president to appear tonight. I was present at the committee of the whole for another issue the other night, and I was totally shocked.
Okay, thank you, Ms. Barnett.
Thank you, Mr. Hall.
Mr. Egan, you have my apology. Thank you.